Hi, it's Ron. I have expressed some doubt about the format or about the availability or visibility of the Law Learnin Wednesday thingies. And I have had a very busy week in addition to that, but I do believe that by virtue of having promised subscribers that they would get a video every week, even though it's not Wednesday anymore, that I should follow up on last week's video, which, as you will recall, was entitled, So You Want to File a Lawsuit. So we talked a little bit about the initial considerations with respect to filing a lawsuit and about the court system. And now, let's say that we've decided there isn't a way for you to resolve your problem, and that in consultation with us, we've concluded that your problem is a legal problem. It's one that may be amenable to solution through the legal system. Let's also say that we have determined that we know how to solve it, and that we're capable of solving it as lawyers. Our office or ourselves can help you with this problem. What do we do next? Let's put aside right now the issue of whether you can afford to have us solve this problem, and I think a separate video would be justified in helping to answer the question of making the budgetary decisions, making the decision of how much should you spend to attempt to solve how much of a problem. And when the when the sunk cost fallacy should not be allowed to unduly influence. It's going to influence you a little bit, but certainly the fallacy aspect of it should not influence the decisions that you make about proceeding financially. Let's assume you're going to go forward with the lawsuit. So we're going to sit down, you're going to tell us what your problem is, and then we're going to put it into fancy language and then file it with a court, right? No! You knew the answer was no by the way I started the question. It was loaded. You tell us your story. Maybe we even convince you to write out a version of your story, to take the time and put together all the emails that you're relying on and the texts and whatever the case may be, the way that you would go about proving the story based on documentation if you can. You show us the relevant documents. Maybe it's a contractual dispute, or maybe there's an employment issue and there's a handbook, whatever documents are going to bear on the case. We interview you. And again, maybe we get you to do some homework. But we don't just take that and turn it into a complaint with fancy words and just sue someone. That isn't the way we do it. We have to satisfy ourselves that if we were the lawyers who represented the party that the lawsuit is going to be against. Asterisk. We'll read the asterisk after I finish the sentence. We have to satisfy ourselves that if we are the lawyers representing the party that this lawsuit would be against, that we would inspect, analyze, confirm, corroborate, challenge the claims that are in this lawsuit based on information that is available to us. We need to get as good and as supportable a version of the story as possible, both to anticipate problems in the case that could result in it being dismissed or you're losing the case, but also to satisfy our ethical obligation not to file a frivolous lawsuit. We need to satisfy ourselves that what you're claiming is true to the extent that we possibly can. Asterisk, bottom of the page, footnote. Before any of this took place, we ran a conflict check. We made sure that we actually can represent you and that we can represent you in this case. Those are two separate things. Representing you means no one in this law firm has represented a client in a legal matter adversely to you, and certainly isn't doing so now, whether it's two sides of a corporate or business or real estate or other kinds of transaction or an employment relationship, certainly a lawsuit. We can't represent you in this lawsuit and sue you in another lawsuit, except under very unusual circumstances, and even then it would be necessary to waive the conflict. That's just the you part. Now let's talk about the you in this matter part. In this matter, you have an adversary. We need to satisfy ourselves that we don't represent your adversary or someone connected to your adversary. And to some extent, and this will vary depending on the practice, interests that are adverse to our existing clients. That is one of the things that makes conflict checks sometimes hairy. There's another level, of course, which is even if there is not a direct client interest at stake, the firm might have an interest at stake. What's sometimes called a positional conflict. It used to be, for example, that back in the day before social media, before cancel culture and social media bans were all the rage, firms that represented plaintiffs in defamation lawsuits, libel, slander, defamation, did not represent defendants as a rule. Not a strict rule. Sometimes you might see them on both sides, but a general practice firm might do them on both sides. But firms that really had a defamation practice were likely to do one or the other. So it would be a positional conflict not to cross over that line, because your clients want to think of you as the vindication of reputation guys, not as the shutting down defamation lawsuits guys. They are not necessarily the same kind of lawyer. Now, what has happened since those days, over the last 10 or 15 years, is that defamation is increasingly being used by firms such as ours, and in my own practice, as a kind of claim meant to actually prevent people from speaking freely. People who have, by virtue of being defamed, had their social media accounts removed, and they're more like the defendants than the plaintiffs in many respects. That has muddied the waters. And I'm just using one example, and it happens to be kind of a sexy example. But the same thing can be true in certainly in employment law. Firms usually do one or the other, unless, again, they don't do a lot of either one. There are some divorce lawyers that always represent the wife, and some divorce lawyers that always represent the husband. And that's your prerogative. As a lawyer, you're not obligated to take anyone on as a client, as a general rule. Sometimes you will be assigned. In New Jersey, we have a mandatory pro bono, which the state sometimes uses to give indigent parties representation by mandating that lawyers provide services free. That has been challenged constitutionally, and that the challenges, unsurprisingly, were rejected by the same court that instituted the policy. That happens a lot, guys. Anyway, that's a little bit about conflict checks. We do the conflict check process. How do we do it? First, you check your internal records, and there are systems for that. Make sure that the names of the parties involved, and if it's, let's say it's an LLC and it has 4 partners, you want to make sure you get the names of all the partners. Other principals, people whose names matter, get that into your system, and you use those names on the first hand to search your existing database of names, and on the second hand, you add those names that you're using as search terms to your database for purposes of future searches. Okay? Even if you end up not taking on the representation, you want to have a record of having spoken to this client about this matter, which could implicate conflicts. In fact, there's a little trick that's sometimes used. You might have seen it in an episode of The Sopranos, where Tony's wife wants to divorce him. And as she goes to each well-regarded divorce lawyer in New Jersey, she finds out that they're all conflicted out. Why? Because Tony called up each one of them to have an initial consultation. And he had no intention of hiring most of them. He hires one ultimately. But what he wanted to do was to spoil them for future adverse representation against him. That's ethical. That's unethical on his part, but non-lawyers are not bound to ethics standards, so he can do it. And the lawyers, they're just giving a consultation. I don't know. Maybe he's going to really hire me. If I get involved with a client, when someone talks to us about a prospective representation, they are entitled to the same attorney-client privilege for purposes of that conversation. As a general rule, and given that we have already cleared conflicts as an actual client. So, in a certain respect, we've already represented them. That is not an unqualified assessment, but that is conceptually the paradigm that we're talking about here. So, a lot of moving parts before we even get to talk to you. Once we talk to you, you give us your story. We'll do some level of investigation, and depending on the case, different levels of investigation might require more or less time. And there are some times when we will do an initial consultation for free, and there's sometimes when we will charge for that. And there may be times when, in order to determine if we could take on a case and do the investigation necessary to conclude whether or not it's a case we think we can handle and should handle, which involves the factual investigation and confirmation of what you've told us, we might have to charge you for that, because otherwise it's very easy to spend 5, 10, 15 or more hours of our time on something that we're not going to be compensated for at all. And we want to make sure that if we do that, we're not among 6 law firms that you spoke to who are also doing that, and then you ended up choosing the one who's, for whatever reason, that you wanted to use, and we're not that firm. So we've invested thousands or maybe tens of thousands of dollars in the prospective representation, and we have nothing to show for it. That will happen in some cases anyway, especially where we have a pre-existing relationship with someone. If someone is already a client of ours, depending on the circumstances, we may charge for that kind of work or we may not. But if you're a stranger to the firm, certainly that's going to be part of the calculus. So we've talked today about conflict checks, about some of the aspects of the investment or the initiation of the representation and confidentiality relationship, and the very important process of investigating the initial allegations or claims that you have to make, and determining that whether they're valid or not, whether there's factual proof of what you've told us has happened, and whether that still stacks up to our legal analysis that you have at least what looks like a meritorious case worth bringing for both you and us. So that's my relatively raw, done from the car outside the gym, Law Learning Weekly for this week. A little bit less on the graphics and editing than last time, but on the other hand, maybe this is a more sustainable model for the time being. Tell me if you like it, less or more. At the end of the day, the show should be about the information and my sparkling personality. So maybe the post-production time that I've been spending has been unnecessary, trying to find a way to make this work for you and for me. And everyone have a great weekend and a good Shabbos. And thanks for listening and subscribing.